In a shocking twist of fate, justice takes a deadly turn. Witness the jaw-dropping moments when corrupt cops are instantly murdered in the courtroom. Like this first cop, who thought this cross-examination would be a walk in the park, until this attorney ripped him apart.
Did you form an opinion as to whether the defendant was under the influence?
Yes, I felt Mr. Woods was under the influence.
Justice takes center stage as corrupt cops are finally held accountable for their actions. In this intense courtroom showdown, watch as the tables turn and these officers face the consequences they thought they'd never see. On May 18, 2018, DUI criminal defense attorney Larry Foreman cross-examined a confident cop on the stand and completely stunned him and everyone else in the courtroom. In fact, the cop's police report got taken away on the stand. Watch the video to the end to know what happens to these DUI charges.
I'm sorry. In part of DUI detection, what are some of the first steps of DUI detection that you learned in your training?
The very first step is obviously the driving of the suspect, your initial contact with the suspect, and then from there you make the determination whether or not field sobriety tests need to be administered, and then you administer those field sobriety tests. After those tests, you determine whether or not to arrest the subject and offer a breath or blood test to the suspect.
Okay. And now getting back to the field sobriety tests, what was the first one you mentioned?
This officer's name is Keith Addison, who arrested a man, Mr. Woods, for DUI. However, the cop did not have conclusive evidence for his act, and Mr. Woods' attorney would certainly take advantage of that.
Horizontal gaze nystagmus test.
Okay, and so what does that entail?
It is a test of your eyes. It's an horizontal nystagmus is an involuntary jerking of the eyes.
What causes that nystagmus?
Alcohol can cause nystagmus.
Okay. And so I'm sorry to interrupt. Continue.
Based on my training, they teach us to look at the pupil size to make sure the pupils are potentially the same size.
If they're not the same size, what is that indicative of?
That could be a medical issue.
Okay.
Mr. Woods' attorney then took a more direct and attacking approach.
Now, how many stops have you performed for suspicion of a DUI?
Hundreds.
And how many of those resulted in arrests?
Hundreds. I can't give you an exact number.
Okay. So you have a vast experience of doing DUI arrest and detection.
I've been doing it for a while.
Okay. Now, were you on duty on January 7th, 2017?
Yes, sir.
Around maybe 10 o'clock that night?
Yes.
Okay.
I think it was closer to 11, but yes.
Okay. Did you observe anything out of the ordinary around that time?
Yes, I was traveling east. I was just on patrol. I can't remember if I had left a call or had conducted another traffic stop. I'm not sure. But I was traveling east on 150 heading towards Stanford, not very far out of the city limits. And a white Mercedes, I was doing the speed limit 55 miles an hour, and a white Mercedes passenger car passed me in the fast lane and then abruptly moved over into my lane, what I would consider cutting me off. Came very close to the front of my vehicle. At that point, the vehicle continued on.
You must pay attention to what the officer said next, because it would be a very important piece of information which would be addressed later on by the defendant's attorney.
I don't have a radar in my car, so I matched speeds with the vehicle in front of me. My speedometer read 65 miles an hour. I initiated a traffic stop. Mr. Woods was the operator of the vehicle. I did observe an odor of alcoholic beverages from the vehicle. I did ask Mr. Woods if he had had anything to drink, and I think he stated 3 to 4 beers, that they had just left a Mexican restaurant.
I'm sorry, did you say that he stated they just left the Mexican restaurant?
I think that's what he stated, yes.
All right, continue.
At that point, I had Mr. Woods step out of the vehicle. I asked him to perform field sobriety test.
Specifically, keep in mind the part where he said he could smell the odor of alcoholic beverages.
Because I could observe the odor of alcohol on his breath even after he exited the vehicle. Mr. Woods really was not very cooperative at first and actually didn't want to take any test. At that point, I explained to Mr. Woods that that was the only way I could to determine whether or not he was safe to be on the roadway. That's how I needed to determine whether or not he could continue on operating the vehicle. Mr. Woods did perform the horizontal gaze nystagmus test for me, where he exhibited all 6 clues. At that point, I asked him to take the.
Your Honor, may we approach?
He probably refused to take the sobriety test because he wouldn't want to stand in the cold, and he wanted to be taken to jail so he wouldn't freeze to death.
Deputy, do you have your citation with you?
I do.
May I have the citation, please?
Yes, sir.
Thank you. All right, so you had the defendant step out of the vehicle and he performed the HGN test. Is that where we're left off?
Yes, at that point, after the horizontal gaze nystagmus test, I asked Mr. Woods to perform the walk and turn test, and Mr. Woods stated that there was no need to perform those.
Okay. Now, I've heard testimony that it may have been called today, but what was your indication from him making that statement?
The attorney then questioned the certification status of the officer, hoping to perhaps get a loose end from there.
So, and just a real quick question back, do you have to recertify for your training, or do you go through a training every so often for DUI detection?
Every 2 years we have to recertify on the intoxilizer, which is the actual instrument that collects the breath and gives the readout for the breath test. As a law enforcement officer, we have to take 40 hours a year just in law enforcement basics, different courses every year that we're a law enforcement officer.
So, based on your 16 years experience, your 40 hours of training, did you form an opinion as to whether the defendant was under the influence?
Yes, I felt Mr. Woods was under the influence. Obviously, that's why he was placed under arrest.
Okay. I have no further questions at this time.
Oh, yes. Mr. Former Cross, when you're ready. Thank you, Your Honor. If I might just have one moment. You may, sir.
You could see from the officer's face the attorney was asking the right questions. He was clearly tensed up and worried.
You have indicated that you've been doing this quite a while, 16 years, is that right?
I feel like that's a substantial amount of time, yes.
I would agree. That's a long time to be doing something like this. So you've been trained, you said recertified. You went to Richmond 16 years ago, I presume?
Correct.
And there you were given, was it, you said a 22-week course at the time?
Yes, sir.
I think they've since changed that. I think it's a little bit longer now, but...
I think it's went longer and then went shorter, and there were some Homeland Security issues that we had to go through, and I think that's why the course actually went longer.
Right. In your training, do you remember being taught to write your reports and make them as complete and as accurate as possible?
That's correct.
And they taught you that because in the future a jury may rely on it, right?
The officer needlessly overcomplicated the answer to the attorney, asking whether the reports would be relied upon. Of course it would. They have to be accurate for a reason.
A judge would rely on it, wouldn't a judge rely on that as well?
I would assume I don't perform judge duties.
Mr. Johnson would rely on this report?
Yes, I believe you would.
I would rely on this report?
I guess you would.
So you made sure that this report is complete, accurate, and is not missing any information?
Yes, we do the best we can. My penmanship is not the greatest, I have to admit. It never has been. There's a limited amount of space that you can write in the reports. I do the best that I can to get all the information. I try to put the pertinent information to the case in the citation. Sometimes you cannot put everything in there.
Is it so hard to use a second page to continue the report?
I just don't have enough room to put it in there, but I do try to get as much information in there as I possibly can.
So you never pick up a second page and supplement it if there's not enough room in the citation itself?
No, sir, I do not have an MDT, which would allow me to do that. I have to do paper citation still, so that makes it very difficult. But no,
So you cannot even supplement it if you have relevant information that must go into that report, you just ran out of room, they're just SOL?
if it must go in the report, it goes in the report.
Fair enough. So I want to dive in. I'm sorry. Let's back up. So
That was a very stupid answer. The officer could just rule out whatever he wished and call it unimportant.
when you were in the right-hand lane on highway, which one was it? 150?
US 150 bypass.
US 150 bypass.
It has several numbers. I think it's 127, 150. I think it's listed as several highways, but yes.
You may be right. I think that's the one that I actually took over. My GPS was.
Yeah, there are several roads.
Right. And you saw Mr. Woods pass you, which you later determined was by pacing him, at least.
Correct.
10 miles over the speed limit.
That's correct.
Okay. And you decided to initiate a traffic stop. Based on that.
Actually, I was going to initiate the traffic stop based on when he passed me and moved over into my lane. At that point, I was already planning on initiating a traffic stop at that point, but then I went ahead and he continued on, so I paced him and paced his vehicle.
When he cut you off, that you made the determination, I'm going to pull that vehicle over.
There was going to be a traffic stop conducted on that vehicle, yes.
And then subsequently you paced him at 65 miles an hour
Correct.
in a 55 mile zone.
That's correct.
And you pulled him over.
That's correct.
And he pulled over, did he continue on for a short while, a long while, or did he pull over right away when he saw your cherries?
I don't remember that. I'm assuming he pulled over fairly quickly.
This wouldn't be the only instance he couldn't remember stuff. It would be a recurring problem, which I doubt was true.
If he would have continued to drive, I would have listed that in the citation.
And did he pull over to the side of the road?
He did pull over to the side of the road, yes.
And you pulled up behind him?
Yes.
Okay. Shortly after that, do you remember approaching Mr. Wood's vehicle?
Yes.
Was his window rolled down, or did you ask him to roll the window down?
I have no idea.
You don't remember?
I do not remember that.
But you've stated that you detected the odor of alcohol coming from the vehicle.
Yes.
How can he detect the odor of alcohol coming from the vehicle if the windows were closed? He was clearly lying. And
did you ask him out of the vehicle immediately right then, or did you go back to the car, radio for backup? What procedure did you follow?
Actually, I don't remember. Normally, if I observe an odor of alcoholic beverages, I'll ask the subject to exit the vehicle at that point. I don't remember that case. I know that you said that I walked back and got back into my vehicle. I don't remember doing that, but I'm sure that's a possibility that I did that to check his license and run his license, but I don't recall doing that. But normally, if I smell alcoholic beverages, I will get the subject out.
He just dismissed any question he didn't want to answer by saying he didn't remember.
Try to perform field sobriety test.
And that's exactly what you did in this case, correct? You asked him out of the vehicle?
Yes.
You stated that eventually you got Mr. Woods to perform the HGN, also known as the horizontal gaze and nystagmus test.
That's correct.
And I remember, because I wrote it down, on direct, you've stated, quote, alcohol can cause nystagmus, right?
That's correct.
And there are other causes of nystagmus as well. Do you remember being taught at the academy?
I'm not a medical doctor, and I do remember that, and I think there are some other drugs, PCP being one, inhalants being one, and if I'm not mistaken, a brain stem injury or something to that effect could cause nystagmus.
Are you aware that heredity or diet can also create nystagmus?
Never heard that.
What about caffeine?
I know that there had been some research done on caffeine, and I think that was, if I'm not mistaken, I remember them saying that they didn't believe that that affected nystagmus.
Hats off to the attorney. He didn't have to make a point. His questions and the answers he got from the corrupt cops were making the points for him.
Let's go back to the when you asked Mr. Woods out of the vehicle. Okay. You've also been taught to look for other indicators of intoxication. You remember the pre-exit, the post-exit. Field sobriety is just one of them. But using your common sense, I believe, we're not leaving common sense at the door, as we've stated. Neither do you. You use your common sense to see, is the subject impaired by alcohol, something else, or if they're just having a medical issue, if it was like a post-accident, let's say, and you need to call EMT, not something that happened here, or EMS rather.
The attorney continued to give the officers slaps indirectly, and he had no responses to them.
And looking over in your report, one of the indicators that are most common, for instance, are red bloodshot eyes.
That's correct.
And Mr. Woods did not have red bloodshot eyes in this case.
He did have bloodshot glossy eyes, yes sir. He did.
And you never wrote that down in your citation?
I believe it is in my citation, yes sir. It's, if I'm not mistaken, it's toward the bottom of the citation.
Oh, you are correct, sir. I do apologize. Bloodshot, glassy eyes. And it was 10:54 at night, correct?
That's correct.
Okay. But he did not have a flushed face, did he?
I don't recall him having a flush
Which
face.
is another indicator of an intoxication.
A very rare mistake from the attorney, the only one he'd made up until this point.
He did not have slurred speech, did he?
I don't recall him having slurred speech, no.
So he spoke perfectly fine.
He didn't speak a whole great deal, but what little he did speak, yes.
He had no trouble getting out of his vehicle?
I don't recall him having
He wasn't
any trouble.
stumbling or falling over?
I don't recall that, no.
He didn't use the vehicle, sometimes they'll use the vehicle to balance themselves as they're about to fall. He didn't do that.
No, sir, I would have listed it if he would have.
He didn't fall over into the pavement as he got out of the vehicle.
No, sir.
He didn't throw up.
No, sir.
You've stated that initially he was a little bit uncooperative, but later he began to cooperate.
No, not really. It's hard to explain. He did what I asked him to do, but yet he would not perform field sobriety tests. When I asked him for his license and insurance, he gave them to me. When I asked him to step out of the vehicle, he did so. When I asked him to take field sobriety tests, he did not want to take those. At that point, I explained to him that that's the only way I can, you've told me you've had 3 or 4 drinks. I smell alcohol in your breath. He did have the bloodshot glossy eyes. At that point, it's my duty to make sure he's safe to be on the roadway for him, his passenger, and the public.
What this cop didn't tell was that he didn't let the man get his jacket from his car, despite the extremely cold weather. That would be the reason he didn't want to do a field sobriety test.
Based on his driving, I didn't think his judgment was very good, almost cutting me off. I asked him to step out. I explained to him that's the only way I can determine whether or not you're safe to drive. He then took the HDN, a horizontal gaze nystagmus test, but then when I asked to do the other ones, he said there's no need in it and would not perform those tests for me. And then, of course, at the detention center, he would not submit to a breath test.
For your information, the man asked for a blood test, but this evil cop declined his request.
Was he polite with you?
I don't know if I would call it polite. He was...
Agitated?
No, he wasn't agitated. He was just matter of fact. I guess this is the best way that I can...
Fair enough.
He didn't seem threatening, but he just was not cooperative either.
Do you remember, I know it's been a long time, as a matter of fact, I'm going to ask this question before I ask my next one. 16 years ago, you did complete the 40 hours, which is standard in Richmond to this day, to complete for the standardized field sobriety and DUI detection training.
That's correct.
Well, the officer, if he had half a brain, would know the man would be at least a little pissed if he got pulled over in the middle of a freezing night, having to be outside without a jacket.
Did you ever recertify at any point? Did you recomplete A-RIDE, which is the advanced roadside and driving education?
I have had the advanced DUI course. I don't know when. It it's been years ago that I have had the advanced DUI training course. I have completed parts of the 40-hour course again. Maybe the whole course, I'm not sure, on the field sobriety test.
Do you remember when that was? I'm just trying to get a feel.
It's been years. It's been several years.
Do you remember during the course and the re-course, you were taught, because I've taken the course myself in Georgia with a DRE certified. He's got all the credentials. He's a DRE. At the jail, you did not perform or ask Mr. Woods to perform any field sobriety tests?
No, sir, that's not standardly what we do. We normally do it, we make our determination on the scene.
And you've, I think I'm repeating Mr. Johnson here, you've stated in one of his questions, Mr. Woods never asked for you to repeat the implied consent?
Not that I recall.
He could have done the field sobriety test at the station and made an exception due to the weather. But of course he wasn't going to. He wanted to arrest the man.
Prior to asking him to submit to the breath test, which he refused. And then you've also stated that it appeared to you that he understood everything.
He didn't ask me. As far as I remember, if he would have asked something, I would have listed it in the report, but obviously he didn't ask anything, so.
This is a spectacular performance from the attorney, a masterclass in defeating the evil at their own game.
Mr. Johnson, I'll give you a moment and any redirect.
Yes, sir. Just real briefly. So, was there ever any mention of any medical conditions that would preclude Mr. Woods from taking any of these tests?
As far as I can remember, Mr. Woods never said anything about a medical condition.
And is it your standard? Would you say, you know what, it's too cold or it's too hot, or I'm just going to pick you up and take you to jail, and then we'll do the test there?
Normally, we try not to arrest someone unless there's a reason to arrest them. I get that the weather's, sometimes it's hot, sometimes it's cold, sometimes it's icy. We do the best we can with what we have.
It wouldn't be that much of an inconvenience to take him to the station for the test. Either he was lazy or he did it on purpose.
We try to take the weather into consideration. We're cold, they're cold. We understand that, but that's, unfortunately, if we feel that there's a need to perform these tests, we're going to administer those tests.
Now, you stated that, well, you don't recall whether he had a flushed face, but could a flushed face also be due to the cold?
I'm sure it could. My face has been red and windburned before.
Okay.
If you did try to consider the weather, you wouldn't have told him to do the test without a jacket and on the roadside.
Now, if Mr. Woods had submitted to the intoxilizer and blown well below the legal limit, what would you do at that point?
His charge would have been amended, as far as I know, to a reckless driving.
Okay. I have no further questions.
Just one, Your Honor, if I may. I apologize.
Take your time. You're fine.
During your interaction with Mr. Woods after you placed him in the cruiser, do you recall at any point Mr. Woods asking you to take him to the hospital for a blood test?
I do not recall
You don't
that.
recall? That's all I have, Judge.
Mr. Johnson, any redirect?
No, sir.
Deputy, you may step down, sir.
Thank you.
However, this is nothing compared to the verbal beatdown this no-nonsense judge gave this next tyrannical cop.
Today is that day.
Dirty cops make things a lot worse than they should be, but sometimes they get to face the consequences of their actions. In this video, we will look at cases where thirsty cops instantly get killed in the courtroom. Starting with the first one, where an angry judge destroyed a cop's whole life. Former Sheriff Jamie Knoll of Clark County grabbed headlines when he was found in contempt of court for violating his bond conditions by possessing multiple firearms in his residence. This controversial figure, famous for his stint on the A&E show 60 Days In, also faced accusations of embezzling millions in local funds for personal gain. The judge's surprising judgment in this case will truly leave you astonished.
I told Mr. Knoll, don't do anything stupid. Do not try to deceive me, defy me. You will not like the consequences. Today is that day. You are not the law. You don't interpret the law. You don't enforce the law. You're not above the law. I find that you are in contempt of this court. Take him into custody.
We need more dedicated judges like him who are passionate about serving the public and standing up for justice. It's time to show corrupt cops that their actions will be punished.
No, that's enough. I'll find you guys in contempt for disrupting the proceedings, and you'll be right there with me. Now, what is an appropriate sanction? The question is, I can sentence him up to 180 days without a trial, or I can sentence him to a day, or I can release him. You know what I think the answer is? 60 days in. That's what I think the answer is today. Before he is released, I'll take your suggestion. I want an independent individual to scour that household to determine that there's no further weapons. I find that Mr. Hurdle's original argument that he was trying to make that I sustained, an officer of the law, every time I go into court, I hear, I didn't know it was there. I didn't know it was there. It really did. You've heard that a million times. You've heard it a million times, and yet you still take them into custody, would be my guess. Every officer in the world has heard, I didn't know it was there. It's my friends. I'm not buying it. It's your burden. It's your responsibility. And today, the court will enforce that. Take more.
This is what dirty cops like him deserve, to rot in jail until their demise. Thanks to the judge's fierce decision, people across the states can rest peacefully knowing that we are in good hands. If you think this cop was tough, then watch this next one who thoroughly exposed the criminal cop before giving him a fierce sentence.
Eric DeValconaire on count 1, the Class E felony of involuntary manslaughter in the second degree.
On Friday, March 4th, 2022, former Kansas City police detective Eric DeValconaire, who was convicted in November of Cameron Lamb in Kansas City, Missouri, appeared in front of Judge Dale Youngs. The way the judge hands down the sentence is a sight to behold.
There are a number of facts in this case that are both aggravating and mitigating, sometimes all at the same time. First and foremost is this undeniable and uncontested fact. Cameron Lamb is dead, and Eric DeValconaire killed him. That's undisputed. Cameron Lamb was by all accounts a helpful and loving son, brother, father, and friend. People who have contacted me and who I have heard from today have described him as funny, caring, giving. Miss Gray called him a protector, a jokester, and my favorite of all the ones that I read, not a saint, but our angel. Also, as I'm weighing all these facts, it can't be overlooked that the events of December 3rd of 2019 were initially set into motion by Cameron Lamb and his decision to chase his girlfriend through city streets at dangerously high speeds, putting motorists and other members of the public at risk. However, those events tragically concluded with the actions of Troy Schwam and the defendant. Pulling up to defendant's house, Sergeant Schwam pulling into the driveway, immediately getting out with his weapon drawn, rapidly moving into the backyard, carport, garage area of the house, and defendant doing the same. Both without taking a breath, without pausing for the briefest of moments to consider where they were going, what they would find when they got back there, whether they were acting lawfully in doing so, and whether there might be some other safer option.
Lamb, 26, was backing his pickup truck into his garage when DeValconaire shot several times, and he died.
At any point, Sergeant Schwam and the defendant could have done this, a fact that is made even more aggravating as the court considers an appropriate sentence, in this case by the fact that the one person who ultimately did take a breath that morning was Cameron Lamb. He did this when at some point, while he was chasing his girlfriend, he decided to discontinue the chase and to go home. The video from the helicopter shows this decision, shows how it played out. Cameron Lamb is not racing through the streets of his neighborhood at this point. He's not driving through yards to get away from anyone. He does not abandon the truck and let it roll into someone's yard while he flees on foot. Rather, he simply pulls into the driveway of his home, pulls around back, puts the vehicle into reverse, and slowly begins backing it down the driveway, under the carport, and into his garage. And as the court has found, an encounter that was over and a situation that had de-escalated was again escalated by what I have found, rightly or wrongly, was their unlawful entry into the backyard carport area and confrontation of Cameron Lamb. This is an aggravating factor. The circumstances of the offense as described during the trial, however, also provide the court with a mitigating factor. I found, as I've considered the evidence in the case, that the defendant, Eric DeValconaire, testified credibly at trial that he was rushing to provide cover for Sergeant Schwam, who had rushed into the backyard with his weapon drawn, prompting the defendant to do the same from the other side of the house.
DeValconaire said Lamb was armed, but the prosecutors believe that the firearm found near him was placed there intentionally.
Negating his obligation to act with reasonable care, as the court found he has failed to do, his natural reaction to protect his partner is a factor for me to also consider. And let's also be clear, and it is hard to accept this distinction, I know that. Murder and involuntary manslaughter arising from criminal negligence are two different things. They are different legal concepts. They are different things. Eric DeValconaire is not Derek Chauvin, who murdered George Floyd. Eric DeValconaire is not one of the 3 men in Georgia convicted of running down and murdering Ahmaud Arbery. This is a mitigating factor. Defendant has no prior criminal history. His ORAS scores him as a low risk in all categories, as his father asked me to do, which I was already going to do, and that is to consider the totality of the circumstances and to consider the totality of the defendant's life. The facts and the circumstances in the history of defendant's career and his life that have been presented to this court have demonstrated he has not hesitated to immediately take action when he believed the circumstances surrounding him warranted it. And this trait has generally served him and others well. It also failed him, as it did on December 3rd of 2019. All of which, however, leads the court back to where it began, an evaluation of the impact of the defendant's crime on Cameron Lamb and his family.
The judge did a great job of explaining to everyone that he was not biased against the officer. He also mentioned the impact on the deceased family, so both sides felt heard.
And the court has found that that happened because the defendant acted without considering or being aware of the substantial and unjustifiable risks associated with his conduct, and that his actions were a gross deviation from the standard of care that a reasonable person would exercise in the situation. Having concluded, as I have, having considered all those factors, I ask counsel if there's any legal reason or cause having been shown why sentence and judgment of the court should not now be pronounced.
Sir.
Eric DeValconaire on count 1, the Class E felony of involuntary manslaughter in the second degree, I sentence you to a term of incarceration in the Missouri Division of Adult Institutions of 3 years. On the unclassified felony of armed criminal action, I sentence you to a term of incarceration of 6 years in the Missouri Department of Corrections. Those cases, or rather those counts and sentences, will run concurrent with one another for a total term of incarceration of 6 years.
DeValconaire was sentenced to 3 years for the involuntary manslaughter conviction and 6 years for armed action. Although the sentence sounds short, his life after getting out was essentially over. If you think this officer had it bad, then wait till you see this next officer who was being cross-examined for arresting George Floyd.
And Mr. Floyd didn't drop while you were interacting with him, correct? No.
Derek Chauvin is the officer who previously arrested George Floyd. He was a former Minneapolis police officer involved in Floyd's fatal arrest on May 25, 2020, where he knelt on Floyd's neck for over 9 minutes while Floyd was handcuffed and pleading for air.
Testified that you were the officer who approached the passenger side of the vehicle. You approached George Floyd on May 6th of 2019, is that right?
That's correct, yes.
And you had your gun drawn when you approached Mr. Floyd, isn't that right?
Yes, I pulled it, yes.
And when you approached Mr. Floyd, he said, "Don't, man, I don't want to get shot."
Something like that, yes.
You told him to undo his seatbelt, correct?
That's correct, yes, ma'am.
And he did that, right?
Yes, he did.
And then you said, "Put your hands where I can see them," correct?
Yes.
And then he put his hands in the air?
Yes,
And then you told him to put his hands on the dash, is that right?
that's correct.
And that was when you grabbed his hand and forcibly put it on the dashboard of the vehicle, correct?
Fallen, yes.
This incident led to widespread protests and calls for police reform across the United States and globally. Watch how Chauvin's expressions change as he gets cross-checked.
And then he put his hands on his head, right?
That's correct, yes.
And there was one officer who said that they were going to take him, right?
That's what I heard, yes.
And you were yelling pretty loud, correct?
Yes, I was, yes. It escalated real quick.
Some profanity as well, correct?
Yes,
And you had your gun drawn the whole time you were giving commands, right?
once I started ordering him and he refused to show me his hands, yes, eventually it escalated to where I pulled my gun, yes, ma'am.
And he was awake, correct?
What's that, ma'am?
Mr. Floyd was awake. Was he awake during this incident?
Yes,
He was conscious?
yes,
He didn't appear to be in medical distress to you when you were pulling him out of the car, is that right? He was standing up, is that right?
I don't know if it was specifically, sometimes he was talking, sometimes he was mumbling. He was incoherent in my mind a lot of the time during there.
But you got him out of the car and you handcuffed him, right?
That's correct, ma'am.
And he stood next to the car, right?
Yes, ma'am.
He asked you not to beat him up, correct?
That's correct, yes.
He was able to walk, right?
Yes, he was.
He continued to talk to you. While you were interacting with Mr. Floyd, he didn't collapse on the ground, correct?
Wait a minute, what was the question? Can you speak up a little louder, ma'am?
While you were interacting with Mr. Floyd, he didn't collapse on the ground, correct?
No, he did not.
Well, the answer is stricken. The objection is sustained.
Your attention was focused on Mr. Floyd, correct?
Yes, it was.
And Mr. Floyd didn't drop while you were interacting with him, correct?
No.
Thank you. Nothing further.
Chauvin was charged with multiple offenses, including second-degree unintentional, third-degree murder, and second-degree manslaughter. He was convicted on all counts in April 20th, 21, and subsequently sentenced to 22.5 years in prison for his role in Floyd's death. Next up, we have the case of an ex-cop who was involved in one of the most heinous things an officer could do.
Verdict reads, we the jury, having found the defendant Aaron York Dean guilty beyond a reasonable doubt of the offense of manslaughter.
In October 20th, 19, former Fort Worth police officer Aaron Dean appeared in front of a Texas jury for fatally shooting Tatiana Jefferson in October 20th, 19. His guilty verdict was a rare conviction of an officer for killing someone who was also armed.
Good afternoon. The jury has sent a note or given me notice that they have reached a verdict. Are both sides ready to receive the verdict?
State's ready, Your Honor. The defense is ready, Judge.
All right. Y'all did fabulous when we did the guilt-innocence verdict, okay? Same rules apply. I don't know what this verdict is. Can't have any emotions, all right? Let's bring them in. Good afternoon. Juror number one, it's my understanding the jury has reached a verdict. Is that correct?
Correct.
Is it a unanimous verdict?
Yes, Your Honor.
Okay. If you hand it, please, to Deputy Nicholson. Mr. Dean. Verdict reads, we the jury, having found the defendant Aaron York Dean guilty beyond a reasonable doubt of the offense of manslaughter, assess his punishment at confinement in the Texas Department of Criminal Justice for 11 years, 10 months, 12 days. They do not assess a fine, and it is signed by the presiding juror. You may be seated. Thank you very much. Members of the jury, as we went through before, I'm going to call your juror number and ask you if this verdict is your individual verdict.
Notice how the devil cop failed to show any emotions. It's as if he didn't want anyone to see that they could get to him.
Number 6, is this your verdict?
Yes, Your Honor.
Juror number 9, is this your verdict? Juror number 14, is this your verdict?
Yes, Your Honor.
Juror number 15, is this your verdict?
Yes, Your Honor.
Juror number 21, is this your verdict? Juror number 31, is this your verdict?
Yes, Your Honor.
Juror number 32, is this your verdict? Juror number 37, is this your verdict? Juror number 38, is this your verdict?
Yes, Your Honor.
Your verdict will be received and filed. Thank you very much. Mr. Gill, Mr. Brissett, is there any legal reason why sentence should not be pronounced?
No legal reason.
Mr. Dean, it's the jury having found you guilty of the offense of manslaughter and assessed this punishment. It's the order of the court you be remanded to the custody of the sheriff, be delivered to the director of the Texas Department of Criminal Justice from the date of your original arrest up until today, which would be the date of sentence. You have the right to appeal the jury's decision. You do so by giving written notice of appeal to the Second Court of Appeals here in Fort Worth within 30 days. If you are indigent and cannot afford a lawyer, I would conduct an indigency hearing to determine if you are indigent. And if you are indigent, I would appoint a lawyer to represent you on appeal and provide you a record of this appeal of this trial at no cost. Mr. Gill, Mr. Brissett, if y'all will remain on his case pending his decision whether he wishes to appeal, and if you'll furnish the information for the trial court certification of appeal before you leave here today, I would appreciate it. Is there an allocution? You may be seated. Thank you very much.
The jury took about 13 hours to reach a decision and ended up finding Dean guilty of manslaughter instead of the more serious charge the prosecutors wanted. Dean's defense argued that his actions were reasonable given the circumstances, but the jury went with the lesser charge in the end. Do you think the jury made the right decision? Let me know in the comments below. And if you liked the video, subscribe so you don't miss out on the next one we have in store for you. Thanks for watching. This is Detective Mystery, signing off.
And next, you'll be left stunned by the confidence of this next cop in court until he realized that he wasn't getting away with his horrible actions.
State of Georgia versus Miles Bryant. Indictment number 24B-00156-4. Count 1, malice murder. We, the jury, found the defendant guilty. Count 2, felony murder. We, the jury, find the defendant guilty. Count 3, kidnapping. We, the jury, find the defendant guilty. Count 4, criminal attempt to commit rape. We, the jury, find the defendant not guilty. Count 5, false report of a crime. We, the jury, find the defendant guilty.
However, this verdict wouldn't be the end to Miles's punishment, and it certainly shouldn't be considering the heinous crime he has committed.
Mr. Bryant, you now have been convicted of 3 felonies. I want to inform you have a right to seek post-judgment relief from your felony convictions by either filing a direct appeal to a higher appellate court or to file a motion for a new trial. You have 30 days from the date I sign and file your sentence with the clerk of court to file a motion for new trial to any and all of the felony charges. You also have 4 years from the date of your sentence, from the date your sentence is final, to file a habeas corpus petition on the felonies.
The judge, as is her duty, further tells Miles his rights, but from the look on his face, he doesn't look particularly remorseful for his actions.
You've also been convicted of a misdemeanor, and you have 1 year to file a habeas corpus on the misdemeanor of false report of a crime. I'm going to ask the jury to go back to the deliberation room and come back and talk to you, and then I'll be back out for sentencing.
Yes, ma'am.
As the court came into session again, Miles's retribution got even worse as the victim's family came out to make a statement.
The victim's family would like to speak and give an impact statement to the court. I'd first like to call up Ms. Jasmine Perez.
All we ever wanted was justice for what happened to her. So I want to thank her for that. But nothing will ever bring her back. And to this day, I still hope that I'll see her again.
Susanna's mother and sisters had been silent all trial, but they clearly couldn't remain quiet any longer.
I just ask that he receives the maximum sentence because no family, no mother, no father, no one deserves to go through this. No one deserves to go through what he went through all these years. These 2 years, I'm sorry. Diciéndome que me la van a mandar en pedazos.
All 7 months, receiving calls, receiving messages, receiving pictures, saying that they were going to return her in pieces.
Cada noche yo no puedo dormir sin pensar en ella.
Every night I can't sleep without thinking of her.
This may have been the last nail in the coffin of Miles Bryant. The pain he has caused the family only gets more apparent in this next clip.
Till you found your daughter. And your daughter, Susanna, did not deserve this. And I just hope that after today, you and your family can find some peace. That is what I wish for you. Hopefully, you will receive some peace now. Thank you.
As a result of the trial and pleas from Susanna's family, ex-Doraville police officer Miles Bryant was sentenced to life in prison without the possibility of parole in the murder case of Susanna Morales. Even though Bryant was an absolute disgrace to the state of Georgia, these next tyrant officers prove that they are capable of no less.
That has endangered my 9 and 11-year-old children.
On 30th of August 2022, Officer Bueno had a confrontation with an auditor by the name of Drew. However, the situation quickly escalated once they came face to face.
What's the best way to do this? Can I twist this way?
Yep.
No volunteer requesting a...
Please leave my cameras running, sir. Please leave my cameras running, sir. And could you go read Azari versus Yahia out of the 10th Circuit Court?
Negative.
And also read Fordyce versus Seattle.
Off the bat, the officer is hostile. However, his attitude only gets worse from here on out.
They're trying to hotbox me. So what are you arresting me for? Or am I still detained? Am I detained or arrested? So you're transporting me, so that's kidnapping. So you never arrested me, you're just kidnapping me, is that it? You've never told me I was under arrest.
You'd think the officers would be scared of their mistreatment being recorded on camera, but his shamelessness remains intact.
So no Miranda, and no telling me I'm under arrest. There's no trespassing signs. From a public road to a publicly accessible parking area for the public to come to the prison. Just laying it out there.
Okay, so you do have the right to remain silent. Anything you say can and may be used against you in a court of law. You have a right to talk to an attorney and have an attorney present with you if you wish. You can choose at any time not to make any statements or answer any questions.
If you think the officer's blatant disregard for the man's rights stops here, you're sadly mistaken.
You are under arrest for trespassing and obstructing.
How did I obstruct? What physical action did I take to obstruct? Please describe it.
I think you're a little confused on how this may work, and that's fine.
I'm not confused. Obstruction is a physical action, sir. I just want to know what...
Probable cause complaint, okay?
I just want to know what I did to obstruct.
That's not how it works. Okay.
Well, you got to write it down. You might as well just tell me now. I mean, you're going to do what you got to do, and I'm going to do what I got to do. I'd rather just educate everybody instead of litigate everybody.
The officer at least had the courtesy to answer Drew's question up until this point, but that is going to change as well.
And you have a body camera?
All right, sir, step on out, please. Okay, face the car right here. Let's put your feet apart. Thank you.
Anything in there?
A whole 30-minute hotbox and kidnapping on video. I bet our law enforcement still somehow finds a way to get away with such an illegal act of forced authority.
All right, the next case is case number 24, PO for Protective Order 23, Jason Jeffrey Bueno versus Drew Rebar. Is that how you pronounce it?
Yes, Your Honor.
All right. And this is a request for a protective order, as I said. I also received from Mr. Rebar a responsive pleading, and we made sure a copy got to Mr. Bueno, right?
Yes, sir.
Okay. With respect to this hearing, I'll hear from both parties.
As this case begins, we'll truly see the real colors of Officer Bueno, as he aims to show himself as the victim in the situation in court.
You both solemnly swear that the testimony today will be the truth, and so help you God.
Absolutely, God.
All right. Thank you. Have a seat. This is a request for a restraining order by Mr. Bueno, so I'm going to ask you first. Can I call you Mr. Bueno or Officer Bueno?
Whatever you prefer, sir.
Okay. I'll ask Mr. Bueno to tell me why you think it's necessary for me to sign a protective order in this case.
Thank you, sir.
So the trial begins, and so do Officer Bueno's endless lies.
On August 30th of 2022, I responded to a call for service at the Northern Nevada Correctional Center at the request of the warden and staff. During the course of that investigation, Mr. Rebar was arrested. That arrest was reviewed for probable cause by Justice Court judges, and Mr. Rebar pled no contest on 6/20 of 23. The deal being for Mr. Rebar to not enter the prison complex for a period of 6 months.
Even in the face of a judge, in the face of justice, the cop doesn't cease to perpetuate his lies. And if you think this is bad, you haven't seen anything yet.
He made a complaint to the sheriff's office that he was tortured during this arrest. That investigation concluded that there was no such evidence and no such torture, period. And Mr. Rebar was adequately notified of that. Since the time that the charges were dismissed, Mr. Rebar has continued to fabricate that this was a false arrest. The court is very well aware of the no contest pleadings and how that works, and has deliberately lied and defamed and edited videos that he has posted.
Lying and defamation? I'm sure we all saw that previous footage of this officer mistreating the man. He's just lying to justify his actions and save his own skin.
The videos that he has continued to post, he's cut off deliberate things that would go against the narrative that he's trying to prove, i.e. body camera footage from myself that showed all the air conditioning fully on and in the low setting. He has cut those off, and he deliberately distorts the facts in order to drum up financial and social support for himself and his cause. Since that time, false statements that he continues to make, I don't care about his personal vile comments towards myself. But this has turned into a frenzy.
Do you know what has turned into a frenzy? The mistreatment citizens receive from cops all across America. It is disgraceful, and this cop is a prime example given his treatment of Drew.
That this situation, deliberately orchestrated by Mr. Rebar, has gone beyond any official capacity that I have as a deputy sheriff, and has clearly threatened my family. And I'm simply asking the court to help protect my family.
Thank you, Mr. Bueno. Mr. Rebar, your comments. Why don't you think I should issue this restraining order?
My actions don't meet the black and the white of the statutes. My actions are protected under Article 1, Section 9 of the Nevada Constitution. My actions are protected under the First Amendment.
Hopefully, the judge will have a better understanding of the law than the officer, as Drew explains his side of the story.
There have been several accusations made against me here that are just in fact untruthful. The only thing that I'm out there doing, Your Honor, is I believe we have a corrupt government. I'm a businessman, as my response says. I didn't want to get off my butt and stop running my business. I'm just out there now watching our government, like our government's watched my business for the last 20 years or so, and they come in every couple of years with their men, with their badges, and with their guns, and they go through my papers, and they examine my business, and it's a biannual audit.
Officer Bueno needs to be reprimanded immediately for his actions. Such cops being allowed to roam the streets and exercise their authority is precisely the issue in America.
Harassment, and I understand this is a unique slapback that I've done here, that it's not generally done this way. But again, as I spoke to my attorney, Rich Salvatore, yesterday, he goes, I've done a lot of these, and it meets the definitions. Thank you for letting me speak.
Thank you, Mr. Rebar, and I'll let you rebut if you want to.
Yes, sir. It's very clear that Mr. Rebar has a case, a personal vendetta that he is out. His YouTube page is full of verbal altercations with anybody that he can strike up.
Bueno's restraining order was denied, but the auditor's victory came at a steep financial cost, underscoring the need for reform in our justice system to protect against frivolous lawsuits. So that brings these cases to an end. What do you think? Did these corrupt cops deserve the embarrassment they endured in the courtroom? Let me know in the comments below. And if you liked the video, subscribe so you can take advantage of the next one we have in store for you. Thanks for watching. This is Detective Mystery, signing off.